Good day, I am Rochelle Sardan from ACC1 Block B, and I will be discussing the 5 subtopics in law and obligation and contracts. So, the first 4 subtopics is under in Article 1331. I will be defining what is mistake, the requisites for mistake to vitiate consent, and the mistake of fact and the substantial error. So mistake is very familiar to us. Everyone made a mistake. So mistake is a false belief about something according to the law on contracts. Mistake or error is the false notion of a thing or a fact that or a fact material to the contract. Mistake means some unintentional act, omission, or error arising from ignorance, surprise, imposition, or misplaced confidence, and a state of mind not in accord with reality, that is according to blanks. So here in Article 1331, let us just answer the question, when does error or mistake vitiates consent? So kailan natin malalaman na ang error na iyon or ang mistake na iyon in contracts is sufficient to vitiate consent? So under the Article 1331, these are the requisites for mistake to vitiate consent. The error or the mistake mismo, it must be substantial error to the object of the contract, the condition which have principally moved one or both parties to enter into the contract, and the third one is the identity or qualification of one of the parties when the same have been principal cause of the contract. So dapat may substantial error or mistake as to these 3 aspects. Later on, I will be giving example scenarios of each of these substantial error. The second requisite for mistake to vitiate consent is the error must be excusable, not caused by negligence. Ang error daw kuno kay excusable na siya kung ang negligence is caused by the counsel nimo. So dili siya connected nimo, dili imong sala kundi sa gahimo sa contract. So it is excusable. The error is excusable if that is the case. So the third one is the error must be a mistake of fact and not of law. So yan nga sinabi ko kanina na ang mistake o pagkakamali ay pwedeng mistake of law at mistake of fact. Pero dito sa artikulong ito ay it's all about mistake of fact. Let us know more about the mistake of fact, which is my third subtopic, which is the mistake of fact. It may be mistake of fact or on law. In general, the mistake to which Article 31 refers is the mistake of fact. That's what I'm saying a while ago. So I will be focusing on mistake of fact, not in law. It may arise from ignorance or lack of knowledge. For mistake of fact to vitiate consent, it must be mistake of fact. Mistake of fact is a mistake not caused by the neglect of a legal duty on the part of the person making the mistake and consisting in. The first is in consisting in the first, the unconscious ignorance or forgetfulness of a fact, past or present material to the contract, or believe in the present existence of a thing material to the contract which does not exist, or in the past existence of such a thing which has not existed, according to the blanks. So in contract of law, a mistake of fact is what occurs when one or both parties involved in contract have mistaken a term that is essential for the meaning. An example of this, it would be if the contract states that a shipment of plates, plato, is to be delivered. Here the contract is referring to the paper plates. However, if one party believes it to be a ceramic plate, it could be a mistake of fact. There are many cases in which a mistake of fact can result in contract being voided. It is important to note that a mistake of fact is different from a mistake of law. In the mistake of law occurs when one party is mistaken regarding the application of a contract law. The fourth subtopic is substantial error, which is connected to my second subtopic. So again, when does the error or mistake vitiates consent? It must be substantial regarding to these three aspects, and I will be giving you different scenarios on each aspect to understand more about the substantial error. So first is mistake regarding object. X signs a contract of sale thinking it was a contract of loan. So, nag-expect si X nga it was a contract of loan but it is a contract of sale. So, there is a mistake of the object. Another example is nagpalit si Ben kang Sarah og breeding cow. But ang gibaligya ni Sarah dili breeding cow. It was a barren cow. So, there is a mistake regarding the object. And ang object ito mao ang two different cows. So, the second substantial error is regarding the conditions which have principally moved one or both parties to enter into the contract. So, both two parties nag-enter sila na sila ay kontrata na gisabutan. But there is an error. So, allow me to give you an example of this. Na na-error ang ilahang kontrata or ang conditions nga naa sa kontrata. So, si X nag-offer, or I will read it muna. X offered to Y a parcel of land for the latter to buy. So, X knew its area to be 500 square meters. It turned out later, after X and Y is signed a contract of sale that the area is actually 350 square meters. So, na-error sa conditions. Expected na ni X na 500 square meters dapat, pero it turned out after the contract signing na 350 square meters lang. So, another example of this is si Sarah na maligya siyahang iPhone 13 worth of 50,000 cash, but gipalit siya ni Ben, naghuna-huna din si Ben nga ipalit niya kay at abi niya na ang kaning product or the iPhone is payable in installments. So na sila kuan na ay mistake nga nahitabo silang conditions. Ben thought that it is installment, but si Sarah na maligya siyang iPhone in cash, not in installment. So na ay mistake sa condition of the contract. The third one is error regarding the identity or qualification of one of the parties when the same have been principal cause of the contract. So the example is X, enchanted by the beautiful voice of Carol which he heard over the radio, decided to produce a concert for her. X phoned Carol and told her about his offer. Carla accepted the offer and signed the contract sent to her by X. In one of Carla's rehearsal, X dropped by and was surprised to see Carla instead of Carol. So na ay mistake regarding to the identity or qualification. Na-expect si X na si Carol yung nadunggan sa radyo, but as X watched the rehearsal, it turned out to be Carla, not Carlo. Carol, rather. It turned out to be Carla, not Carol. So, na ay mistake regarding to identity qualification. Expect siya nga si Carol, pero it turned out to be Carla. So, another example of this is si Sarah, ibaligyan niya yung car to Ben. Sarah thought that Ben is a lawyer. So, nag-expect si Sarah nga si Ben is a doctor. But it turned out Ben is not a doctor, but instead, he is a lawyer. The mistake here is not a material as to avoid the contract. Another example is, si Ryan donated his car to Anna. Ryan thought that Anna was his half-sister. It turned out that Anna is not related to Ryan. The mistake as to identity of Anna in this case is material because his identity was the principal reason or consideration for the donation. So that was all about the Article 1331. Remember that in Article 1331, or specifically in contracts, it was all about the mistake of fact, not in law. So that was all. Then let's go to my fifth subtopic, which is the persons who may ask for annulment. It is not annulment na it's all about marriage lang. It's all about the annulment of contracts. Kailan mapapawalang visa yung contracts. So I will just report who are the persons who may ask for annulment. Not all people, not both parties can ask for the annulment. So ang pwede lang maka-ask for annulment is the person who is the victim. So in both parties there is a victim and like a guilty person, a guilty party. So the victim are the one who will ask for the annulment. So according to the book, as a general rule, the action for annulment of contracts can only be maintained by those who are bound either principally or subsidiarily. Only the victim or the principal or the subsidiary party may ask for annulment, not the guilty person nor his successor. So again, the guilty party, including his successors in interest, cannot ask for annulment sa kontrata nila. So that was all about the substantial error, the mistake of fact, requisites for mistake, the vitiate consent, mistake defined, and the persons who may ask for annulment. So those are my 5 subtopics that I am sharing with you today. Thank you for listening. By the way, again, I am Rochelle Sardan from ACC 1 Block B, and this is the contracts.